So thanks everybody. Welcome to the webinar on body corporate disputes arising from flood damage. My name is Penny Sullivan. I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. Apologies again for the technical difficulties we've had at the start of this webinar. We start, as always, with our acknowledgement of the traditional owners of the land on which we are holding today's webinar. In Brisbane, they are the Turrbal and the Yagara people. We pay deepest respects to elders past, present and emerging. As this webinar is being viewed by people across Queensland and Australia, we also pay respects to the traditional owners throughout the country. We recognise Aboriginal and Torres Strait Islander peoples as the traditional custodians of the lands in Australia and recognise their continuing connection to land, water and culture. We acknowledge the stories, traditions and living cultures of Aboriginal and Torres Strait Islander peoples and commit to fostering a culture of learning from and working with First Nations peoples in the spirit of reconciliation and access to justice. We extend a warm welcome to any First Nations people listening today. So today we are really pleased to welcome Anthony Pitt, who's Special Counsel Litigation and Dispute Resolution, and Hayley Harvey, is a Senior Associate Litigation and Dispute Resolution from Hopgood Gannam Lawyers, to talk to us about the key legal issues that might arise following flood damage caused to property within a body corporate scheme, including who is responsible for repairing damage caused by floods or storms, insurance implications, and what lot owners might be able to do if damage has not been fixed. I'll let Anthony and Hayley share a bit more about themselves when I hand over in a moment. Before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have that recording available to download later today or tomorrow. A link for the PowerPoint has been emailed out to everyone who registered and that can be downloaded from our website, and I've also made it available through the handouts section of the GoToWebinar control panel. We do encourage you to ask questions. Just type your question into the question box on the control panel and we'll read your question out. We will hold questions until the end of the presentation, but feel free to type them in as you think of them. So we're going to hand over now to Anthony and Hayley, and I'll talk to you again at the end of the session. So over to you. Thanks so much, Hayley and Anthony.
Thank you, Pam, for the introduction and welcome everyone. I acknowledge country and pay my respects to elders past. My name's Hayley Harvey and I'm a Senior Associate in the Litigation and Dispute Resolution team at Hopgood Gannam Lawyers, and my colleague Anthony Pitt is Special Counsel in the same team. We specialise in body corporate disputes. Disputes between a body corporate and lot owners and between lot owners themselves can occur in community management schemes when damage has been caused to property within a scheme by extreme weather events, as it's often unknown or it's difficult to determine who's responsible for the damage caused or for rectification of damage within lots or the common property. The Body Corporate and Community Management Act of 1997 and applicable regulations, as well as the Community Management Statement, known as a CMS for the scheme, provide the framework for who within the scheme is responsible for particular areas of the scheme. Today we're going to discuss the provisions of, in particular, the provisions of the Body Corporate and Community Management Standard Module Regulation of 2020. However, the regulation which will apply to the relevant scheme can be found in the CMS for that scheme. Of course, we can't consider every conceivable possibility in respect of a community management scheme, so today's presentation will be a general overview of the current position in respect to the rights and obligations of lot owners and body corporates under the Act and the standard module. We haven't considered, for example, the accommodation module and other modules which also might apply to schemes. This is our agenda for today. So we're going to discuss the following matters: who's responsible for insurance within the areas of the scheme and what should the insurance cover. If insurance does not cover the damage, we consider what areas and items within the scheme the body corporate are responsible for, and what areas and items of the scheme a lot owner is responsible for. And in the event that the body corporate is responsible for an area in which the damage is sustained and the body corporate either fails or refuses to rectify the damage, we'll consider what lot owners can do to require the body corporate to fix the damage or to pay the cost of fixing that damage. In that respect, we'll also consider the commencement of proceedings and the process for proceedings in the Office of the Commissioner for Body Corporate and Community Management, including what types of proceedings can be commenced, who can commence the proceedings, who would be the respondent in such proceedings, and what orders might be available to the applicant of those proceedings. In respect of who's responsible for insurance cover within a body corporate, Section 189 of the Act provides that a regulation may require a body corporate to put insurance in place for the scheme. Part 6 of the standard module, which is the module we're considering in this particular circumstance, outlines the body corporate's obligations to obtain and maintain certain insurance for the scheme, including building insurance and public risk insurance. Relevantly, a body corporate is required under Section 197 of the standard module to insure the common property and the body corporate assets for full replacement value. That insurance is required to cover, to the greatest practicable extent, damage and costs incidental to the reinstatement and replacement of insured buildings, including the cost of taking away debris and the fees for architects and other professional advisors, and reinstatement of the property to its condition when new. The body corporate's responsibility when insuring a building depends on how the community title scheme is registered. So if it's registered as a building format plan, which might be, for example, a multi-storey block of units, the body corporate must hold insurance for the full replacement value of each building, which contains a lot. So some schemes might have multiple buildings, but so long as they contain a lot, they'll be required to insure the building. If a scheme is registered as a standard format plan, so low-rise developments such as townhouse complexes, the body corporate must insure each building to its full replacement value where the building on one lot has a common wall with a building on an adjoining lot. However, if there's no common walls and the structure is freestanding, then a lot owner is responsible for their own building insurance. The body corporate building insurance will cover the full replacement value of the building structure, including improvements and fixtures. So relevantly, Section 195 of the standard module provides that the building includes improvements and fixtures forming part of the building, but it does not cover temporary walls, floor, ceiling coverings, or fixtures which are removable by a lessee or tenant at the end of a lease or tenancy. Doesn't cover mobile or fixed air conditioning units servicing a particular lot, or curtains, blinds, or other internal window coverings. It doesn't cover carpet, and it doesn't cover, it doesn't have to cover mobile dishwashers, clothes dryers, or other electrical or gas appliances which are not wired in or plumbed in. That section also provides that damage for coverage under insurance required to be put in place by the body corporate means damage from earthquake, explosion, fire, lightning, storm and water, and glass breakage, and damage from impact, malicious act and riot. In Winnipeg Grange, the adjudicator there held that a body corporate was required to obtain flood insurance as part of its building insurance policy. The adjudicator stated in that respect that in that instance it was a different module which applied, but the provision was almost identical to Section 195 of the standard module, and the adjudicator stated that while flood is not specifically mentioned, he was satisfied that the water damage covers damage from water in different ways and includes flooding. The adjudicator also held that pursuant to the requirement in Section 94 of the Act, which requires a body corporate to act reasonably, that he was satisfied that it is unreasonable for the body corporate to fail to obtain flood insurance in an area recognised as a flood risk. Now that decision was appealed to QCAT, but the appeal was dismissed by member Barlow QC. In those circumstances, the things which ought to be covered by the body corporate building insurance under the standard module include permanent fixtures, which may include, for example, toilets, baths, sinks, basins, cooktops, ducted air conditioners, but as I said earlier, not removable or mobile air conditioners, bench tops, built-in cupboards but not movable cupboards, windows and doors and fixed tiling. The public risk insurance required for a scheme that the body corporate is required to take out is outlined in section 206 of the standard module, which provides that the body corporate must maintain public risk insurance of the common property and relevant assets to compensation for death, illness, bodily injury and damage to property to the extent of at least $10 million for a single event and at least $10 million for a single period of insurance. However, section 189(2) of the Act provides that the body corporate can obtain insurance which exceeds the compulsory requirements. It's for that reason that it's important to look at the policy which is in place for the particular scheme. You'll also note that different insurers and policies can contain different levels of cover in any event. And so in the first instance, a person wanting to know what is covered by their body corporate insurance should locate a copy of the relevant policy for the scheme, because that can generally set out what will be covered in their particular instance. The policy can be obtained from either the body corporate manager or the body corporate committee, but it should also be attached to their most recent notice of AGM. Once the policy is obtained by the lot owner, it should be checked for the extent of its coverage, or the lot owner could speak to the body corporate committee in respect of the coverage and whether the damage that is of concern to them is covered by the policy. If the damage is covered by insurance, the body corporate as the policy holder will generally need to lodge the claim, and the lot owner will need to discuss that process with their body corporate committee once the insurance company has been informed of the claim. If the body corporate is not required to obtain insurance in respect to parts of the scheme, for example, individual lots, then the lot owner ought to obtain insurance for those areas. However, unless provided for in the scheme's CMS bylaws, there's generally no obligation for a lot owner to have insurance for their own lot. I've just put in some images here just to illustrate the difference between a building format plan and a standard format plan. Because as noted earlier, the insurance coverage required may be different depending on which type of plan the scheme is registered under. So who is responsible for damage caused by floods and storm if it's not covered by insurance? In the event of flood or storm damage, the body corporate and its members, the lot owners, will need to cover the costs of restoring the scheme to a good and structurally sound condition if the damage is not covered by the insurance. The answer to the question of who is responsible for fixing such damage depends on a number of factors, in particular where the damage is located. That is, whether the damage is located within a lot or within common property generally. That's assuming, however, that there's no causation issues such as defects which cause the damage rather than it being directly from the flood or the storm itself. In general, the body corporate will be responsible for restoring the common property and the body corporate assets, while the lot owner will each need to cover the costs of fixing their own lot and any contents of their lot. Relevantly, Section 10 of the Act provides that common property for a community title scheme is effectively freehold land forming part of the scheme land but not forming part of a lot in the scheme. So anything that's not a lot is generally common property. However, the responsibility is not quite that simple, as the body corporate are required to maintain more than just common property of the scheme. In that respect, sections 94 and 152 of the Act require the body corporate to administer, manage and control the common property of the body and the body corporate assets reasonably and for the benefit of owners of lots in the scheme. The body corporate are required to act reasonably in anything that it does and must comply with the obligations with regard to common property and body corporate assets that are set out in the regulations. Section 95(1) of the Act bestows on the body corporate all powers necessary for carrying out its functions. So Section 159 of the standard module sets out the additional things that the body corporate might also be responsible for. That That section provides the body corporate must maintain common property in good condition, including to the extent that common property is structural in nature, in a structurally sound condition. To the extent that lots included in the community title scheme are created under a building format plan of subdivision, the body corporate must maintain in good condition railings, parapets and balustrades on, whether precisely or for all practical purposes, the boundary of a lot and the common property. Windows, doors and associated fittings situated in a boundary wall separating a lot from common property. And roofing membranes that are not common property, but that provide protection for lots or common property. They're also required to maintain the following elements of the scheme that are not common property in a structurally sound condition: foundation structures, roofing structures providing protection, essential supporting framework, including load-bearing walls. In respect to the boundaries of a lot under a building format plan, the lot boundaries are generally defined by the centre of the wall, the floor or the ceiling of each of the lots. And the obligation to maintain common property includes an obligation to maintain utility infrastructure that forms part of that common property. So the dictionary to the Act defines utility infrastructure to include cables, wires, pipes, sewers, drains, ducts, plant and equipment by which lots or common property are supplied with utility services. And that's lots in plural, not just to one lot. In that respect, the exception to the utility infrastructure, it's not common property if it's a device for measuring reticulation or supply of water for a scheme established after January 2008, or if it supplies only one lot, is within the boundaries of the lot and is located other than within a boundary structure for the lot, so not the floor, wall or ceiling, which is the boundary of a lot or another lot or common property. In that case, it would be the utility infrastructure would not be common property. If the utility infrastructure is located within common property, but is located pursuant to an agreement with the body corporate or the original owner, then it also won't be common property utility infrastructure. If the body corporate is responsible for the area that the damage is sustained in, it'll also be relevant to consider the scope of their duty to maintain that property. The body corporate's duty to maintain in the context of flood or storm damage includes rectifying the source of the damage. For example, if there was some defect which allowed the water to enter the scheme, such as cracks or the like, rectifying damage which is caused by the flood or storm, and work that may be reasonably expected to minimise the need for future maintenance and for the reasonable prevention of future damage. The District Court of Queensland, in the decision of Magog, which I've put up on the screen, discussed in detail the body corporate's obligation to maintain and keep in good repair the common property. In doing so, the court decided that the body corporate's obligation to maintain and keep in good repair common property is a duty of strict liability. There has been a breach of the duty as soon as something in the common property is no longer operating effectively or at all, or has fallen into disrepair. And the duty of the body corporate is owed to each lot owner, and its breach gives rise to a private cause of action under which damages may be awarded to a lot owner for breach of a statutory duty as provided for by Section 182 of the Act. In Coronation Towers, the adjudicator made the following comment: the duty of the body corporate to maintenance the common property can include replacement if repair of the common property is no longer possible or economically viable. So the court decisions support a position that the duty on the body corporate to maintain the common property requires that they take reasonable steps as soon as possible to rectify any damage. And if it cannot be rectified, then they're required to replace the damaged property. What areas are lot owners responsible for? Generally speaking, lot owners will be responsible for rectifying any damage which the body corporate is not responsible in respect of their own lot. So that includes fixtures, fittings, or utility infrastructure located entirely within that lot owner's boundaries. Responsibility may depend upon the location of the cause of the damage, and if it's caused by something for which another is responsible, they may have recourse in respect of that damage. However, in terms of flood damage, unless there is such a defect in another part of the scheme, that won't be relevant. A lot owner will also be responsible for fixtures or fittings on common property, which are installed by that owner or occupier for the owner or occupier's own benefit, pursuant to section 187 of the standard module. They'll also be responsible for utility infrastructure, including within the common property, if that utility infrastructure relates only to supplying utility services to the owner's lot and is a device providing a utility service to that lot. One particular issue that we were asked to discuss today, which came up, I understand, in a previous webinar, is if a car is parked on common property, in a common property car park of a scheme, who's responsible for damage caused to that car by floods or storms? While that issue will depend upon the particular facts of the matter, generally speaking, a body corporate will only be responsible for damage to personal property on common property if the damage has been caused by some contravention of the Act by the body corporate or some negligence on their behalf. In other words, parking on common property is generally at the risk of the owner of the car. But as I noted earlier, the body corporate does have insurance which may assist in respect of removing debris, which might include a damaged car which is located within the common property. Exclusive use areas are another kind of exception, I guess, to the general rule, and is another factor which needs to be considered as to who's responsible for damage within a scheme. The exclusive use bylaw by which common property is granted to a lot owner will often contain conditions upon which the exclusive use is granted, including a requirement that the lot owner maintain and rectify the area if it is damaged. If there isn't any condition which provides for the maintenance or operating costs of the exclusive use area, then pursuant to section 173 of the Act and 192 sub 2 of the standard module, an exclusive use bylaw is taken in the absence of other specific provision in the bylaw for maintenance and operating costs to make the owner of the lot to whom exclusive use or other rights are given responsible for the maintenance of and operating costs for the part of the common property to which the exclusive use bylaw applies. Section 1923 provides that in the absence of other specific provision within the bylaw, the lot owner is not responsible for maintaining in good condition roofing membranes that are on the common property to which the exclusive use bylaw applies, or provides protection for lots or common property. Nor are they responsible for maintaining in structurally sound condition the foundation structures, roofing structures providing protection, or essential supporting framework, including load-bearing walls. That's on the part of the common property to which the bylaw applies, other than those which are constructed by or for that lot owner. Section 177 in the Act provides that an exclusive use bylaw must not give exclusive use to the rights and enjoyment of or other special rights about utility infrastructure that is common property or a body corporate asset. So, depending on the specific provision of the exclusive use bylaw, a lot owner who's been granted exclusive use of common property will generally be responsible for its maintenance, other than maintenance and operating costs, other than structural elements like roofing membranes, supporting framework, and utility infrastructure, which will remain the responsibility of the body corporate. How can a lot owner or body corporate prove who's responsible? As discussed earlier, if the damage is caused rather than directly by the flood or storm, but due to a defect within the scheme, such as a roof leak or cracks in the walls of the scheme, who will be responsible for the damage will depend upon the location of the cause of the damage. The reported decisions with respect to water damage require the issue of the location of its cause to be determined before the adjudicator can determine who is responsible. The lot owner or the body corporate, in order to facilitate the adjudicator making such a decision, might obtain expert evidence to confirm where the cause of the damage originates, or other ways might be to illustrate the location of the cause by taking photographs or relying upon plans of the scheme to illustrate the location of the cause of the damage. In Bluewater's Caloundra, the adjudicator stated that it seems more likely than not that water coming through the walls has contributed to damage to the applicant's apartments. This is evidenced by both expert reports commenting on damage consistent with water ingress at cornices and walls. The body corporate has a responsibility to maintain the common property exterior of the building in good condition, as well as any doors, windows and associated fittings situated in those walls, which is what I discussed earlier in respect to the standard module. And so any damage from water coming through the walls or around windows is damage that I'm satisfied the body corporate should be responsible for. Similarly, in Warrego Lodge, the adjudicator noted that there were cracks in the exterior wall at the northern end of the building which let rainwater in, which damaged a bedroom in the lot owned by the applicant. The adjudicator noted that the water had penetrated up through the concrete slab and the carpet was irretrievably damaged and had to be replaced. In my view, the body corporate's obligation would involve a duty to inspect the common property, to inform itself of the state of the structure and to rectify any known defects. For that reason, the adjudicator was satisfied that the ingress of water was facilitated by the cracks, as found by an expert report. The adjudicator stated that contrary to the view held by the body corporate, if the body corporate fails in its duty, it is liable to an owner suffering consequential damage to property. And the example given in the legislation particularly contemplates the damage of furnishings caused by water ingress through common property. Following an event such as extreme flooding and storms, it may be necessary for the body corporate to undertake works to comply with its obligations to ensure that the scheme is structurally sound and maintained in good condition, which might require the body corporate to inspect areas of the scheme which are contained within lots of the scheme and not common property. In that respect, Section 163 of the Act provides that a person authorised by the body corporate may enter a lot or common property and remain on the lot or common property while it's reasonably necessary to inspect the lot or common property and find out whether work the body corporate is authorised or required to carry out is necessary, and or to carry out the work the body corporate is authorised and required to carry out. The power of entry can be exercised at any time with or without notice in the case of an emergency or otherwise after at least 7 days written notice. I'll now pass over to Anthony, who will discuss what lot owners can do to require a body corporate to fix the damage or pay the costs of fixing the damage and the commencement of proceedings and the process for such proceedings. Over to you, Anthony.
Thanks, Hayley, for that. As Hayley mentioned, I'll be speaking generally about the steps that can be taken should a body corporate not rectify the damage, and as a last resort, should the body corporate still not do so, the process of commencing a proceeding in the Office of the Commissioner for Body Corporate and Community Management. So if you've established that the body corporate is responsible for rectifying the damage in accordance with its statutory duty, questions will arise as to how long a body corporate has or should take to rectify the damage. Put simply, in the circumstances of flood or storm damage, a body corporate will breach its statutory duty if it fails to rectify the damage within a reasonable time. What's a reasonable time will, of course, depend on the circumstances of each case. Some of the matters to be considered and to be taken into account include, firstly, the nature of the damage in terms of the relative importance of the things that are damaged. In other words, some items might need to be repaired on a shorter time frame or more immediate time frame than others. And that will include a consideration of things like whether the damage is affecting the use or enjoyment of any lot or common property, whether the damage is any form of hazard within the scheme, and how urgent or necessary it is to repair the damage. Another thing to consider is the extent of the damage and what will be involved in repairing it, including things like how long it's actually going to take for the repairs to be performed, how long it's going to take to get trades to perform the repairs, and how long it's going to take to get materials needed to perform the repairs. The steps being taken by the body corporate to investigate, obtain quotes, and authorise the repairs should also be considered. And that can include looking at how far along the body corporate is with that process and how they're going with it, and what challenges they might be facing. And lastly, you also need to take into account the times required for any committee meeting or EGM to be called with respect to organising or authorising the repairs, because that needs to be taken into account also. The case of Tank Tower is an example of a case where an adjudicator considered whether a body corporate had acted within a reasonable time with respect to maintenance issues. And in that case, I put the quote on the slide, the adjudicator said, what's a reasonable time to rectify maintenance issues such as lighting will depend on the circumstances. This will include when the body corporate was notified of the failure, who was notified, the relative importance of the particular light in question, and what's necessary to rectify it. If to fix the light requires engaging an electrician or contractor rather than the building manager just simply changing the light bulb, it's not reasonable to expect the body corporate to rectify it instantly. Where a contractor is required to be engaged, at least the committee will need to pass a resolution authorising the expenditure, and there are minimum times for that to occur. The decision in the graduate, which is another decision, that also made comment about reasonableness and the timing of works, and that concerned a dispute arising out of flood damage. As a closing comment, the adjudicator stressed the need for objective, independent opinion in being able to decide that question. And I'll just read the brief passage from there. The adjudicator said, the applicants may have an opinion as to when and how the body corporate carries out work. However, unless they can objectively demonstrate, including where appropriate or necessary with evidence from a person with appropriate qualifications or expertise, that the work should be done immediately, there may be a reasonable basis for the work to proceed instead at the earliest opportunity. Many of the issues raised by the applicants relate to significant maintenance matters. While there is possibly extensive expenditure proposed, the body corporate needs to ensure it decides to do things in a reasonable manner in compliance with its obligations. It is not reasonable to delay work just because an owner may not be able to afford it. Ordinarily, work is financed through contributions paid by owners, and a body corporate may also decide to borrow amounts if necessary. Additionally, what is a reasonable time may of course be significantly greater time than otherwise in the circumstances of a flood, where not just the particular scheme in question has been affected, but entire streets, suburbs, cities, and regions have been affected, and undoubtedly many schemes in those areas as well. That all places significant strain on insurers, repairers, trades, and supply of materials, and this will cause the body corporate's task of taking appropriate steps to repair the damage to be quite challenging. All of that needs to be taken into account when assessing the body corporate's actions. So if a body corporate is not rectifying damage or is not acting as speedily as you believe is appropriate, there are a few steps you can take to try to rectify this. Initially, the first thing to consider is whether you are suffering any loss by the delay, and whether there is anything you can do to minimise your loss. That's important because if you don't take steps to mitigate your own loss, then that can be held against you later, and you may not be able to recover compensation for loss that you ought to have reasonably prevented yourself. Once you've got that out of the way, The second thing to consider is whether there's anything you can do to help the body corporate. This can include assistance with obtaining quotes, locating and speaking with contractors, and even locating and speaking with experts if there's any specific damage that ought to be prepared that's not straightforward. It's in every lot owner's interest to do this, and that's because if a body corporate unreasonably delays in rectifying damage and breaches their statutory duty, in addition to being required to rectify the damage, the body corporate might also be ordered to pay compensation to anyone who has suffered loss as a result of those delays. And every lot owner will be asked to contribute to those amounts. So if lot owners can help out in any way, they should. The third thing to consider and bear in mind is to ensure that a lot owner responds to any body corporate communications that come out about repairs, including any motions with respect to repair works to be undertaken, and that lot owners vote in response to them. Next, and importantly, the fourth thing to consider is making contact verbally and most importantly in writing with the committee with respect to what action has or hasn't been proposed, and make a specific request to them to take certain action. In doing so, you should set out your concerns, what has and hasn't happened, what loss you are suffering, and what you want the body corporate to do, including any proposals and quotes you have for the rectification of the damage. If any general meeting is proposed, that might also include submitting appropriate motions that you want to be considered. Lastly, and if all of the above fails, then you may wish to engage the dispute resolution provisions under the Act to require the body corporate to undertake the repairs, challenge any motion passed or not passed with respect to the repairs, or claim compensation for any loss suffered. And I'll talk about these claims generally. Now, Chapter 6 of the BCCM Act sets out a dispute resolution process that exclusively governs certain types of disputes between persons relevant to a body corporate scheme. And consideration must first be given to whether the dispute falls within the parameters of the Act. And this is important because applications can be rejected by the Commissioner's Office and will not be permitted to proceed if those parameters are not met. There's three things that need to be considered. The first thing is to consider whether the dispute falls within the permitted types of disputes in the Act. And the permitted types of disputes are contained in the definition of dispute in the Act as being disputes between the various people I've set out on the slide, being between an owner or occupier of a lot and the owner or occupier of another lot, a dispute between the body corporate and the owner or occupier of a lot, dispute between the body corporate and the body corporate manager, dispute between the body corporate and the caretaking service contractor, the dispute between the body corporate and a service contractor, a dispute between the body corporate and a letting agent, a dispute between the body corporate and a member of the committee, a dispute between the committee and a member of the committee, or a dispute between the body corporate and a former body corporate manager for the scheme in certain circumstances. It seems to me, though, that the majority of disputes about flood damage where the body corporate is responsible for rectifying the damage will fall within the category in subparagraph B, which is a dispute between the body corporate and a lot owner. Another important element to the requirement for there to be a dispute is that, and to save stating the obvious, there must actually be a dispute between the parties themselves that cannot or has been unable to be resolved and that requires adjudication. A similar issue arose in the graduate decision that I mentioned before, where amongst a whole pile of other things, the applicants, two lot owners, submitted that a rainwater tank floated onto the scheme land during the flood, and they wanted the committee to be authorised to engage someone to remove the tank and to do all sorts of other works around the scheme as well. But in considering that, the adjudicator said that the problem is that there's no evidence that the body corporate has been asked to do the work proposed in that outcome, and there cannot be a dispute if the body corporate has not been asked to do the things stated, and they refer to a district court decision about that. And the adjudicator finished that by saying, there is no dispute between the applicants and the body corporate to warrant consideration of the jobs listed. I appreciate the jobs are considered to be a consequence of the flood event, but that circumstance alone does not create a dispute with the body corporate. The body corporate needed to be asked to do the proposed work and to oppose doing it for there to be a dispute. And that in some ways comes back to my comment before about internal dispute resolution and putting specific requests to the committee and seeing what their response is. So the first element is a dispute. The second element is to consider that whether the dispute falls within one of the enumerated purposes of Chapter 6 of the BCCM Act. And relevant to disputes about flood damage, these are to establish arrangements for resolving disputes in community title schemes about contraventions of the Act or the CMS, or the exercise of rights or powers or the performance of duties under the Act or the CMS, which would be the types of things we'll be talking about today. The third thing to consider is whether the remedies sought to be obtained in the dispute are orders that can lawfully be made by an adjudicator. And relevant to disputes about flood damage, an adjudicator can make an order that is just and equitable in the circumstances, including a declaratory order, to resolve a dispute about the things I mentioned before, contraventions of the Act or the CMS, or the exercise of rights or powers, or the performance of duties under the Act or the CMS. An adjudicator can also make an order that requires a person to act or prohibit a person from acting in a stated way. And without limiting the types of orders that can be made that I mentioned just now, Schedule 5 of the BCCM Act lists 26 different types of orders that an adjudicator can make. I won't go through all of them as they're not all relevant, but the types of orders relevant to a dispute about flood damage include an order, and I put these on the slide, an order requiring the body corporate to take take action under an insurance policy to recover an amount or to have repairs carried out. An order requiring the body corporate to call a general meeting of its members to deal with stated business. An order declaring that a resolution purportedly passed at a meeting of the committee for the body corporate or a general meeting of the body corporate was void. Or if satisfied, a decision to pass or not pass a motion at a general meeting of the body corporate was unreasonable, an order declaring that a motion was invalid or giving effect to the motion as proposed, or a variation of the motion as proposed. Lastly, in terms of permitted orders, Section 281 of the Act is a specific provision allowing the adjudicator to make certain orders relevant to disputes where a body corporate is found to have breached its statutory duty in these circumstances. And it provides that the adjudicator may order the person to carry out stated repairs or have those repairs carried out to the damaged property, provided those repairs are no greater than $75,000, or pay the applicant an amount fixed by the adjudicator as reimbursement for the repairs carried out to the property, provided that amount is no greater than $10,000. So to summarise that short aspect there, it's important to ensure that your dispute is framed in a way so that it firstly discloses a dispute, secondly, it's against the correct parties that the Act permits, and thirdly, it seeks orders that an adjudicator has jurisdiction to make under the BCCM Act. Now I'm just going to discuss the three most common steps of dispute resolution, being internal dispute resolution, conciliation, and adjudication. In the majority of circumstances, and unless it's pointless or urgent, an applicant can't proceed straight to adjudication. It's therefore important to understand what other steps need to be taken first. The first step is internal dispute resolution, and the Commissioner may reject an application if the Commissioner reasonably believes that an applicant has not made a reasonable attempt to resolve the dispute by internal dispute resolution. The term internal dispute resolution is defined in Schedule 6 to the Act to mean the resolution of a dispute by the parties to the dispute using informal processes or the community title scheme's body corporate processes. And examples of internal dispute resolution are given by the parties communicating with each other, by writing to the committee for the body corporate, or by presenting a motion for consideration at a general meeting of the body corporate. And as I mentioned, this is one of the steps that I discussed before, and it's important that this is taken at an early stage to see if the dispute can be resolved informally. The second step after internal dispute resolution is conciliation, and the Commissioner, again, may reject an application if the Commissioner reasonably believes that the applicant has not made a reasonable attempt to resolve the dispute by department conciliation, unless the matter isn't appropriate for conciliation for any reason. Conciliation is a process where an independent person helps the parties try to resolve the dispute. It's an informal process where each of the parties can have their say and put forward solutions with a view to reaching a mutually acceptable agreement. The conciliator doesn't decide the dispute, rather they try and assist the parties to work out a resolution to the dispute, and anything said or done in the conciliation session is inadmissible in a proceeding that occurs subsequently. If an agreement is reached, that'll be set out in writing and signed and can be made as a consent order of an adjudicator if necessary. Otherwise, if no agreement is reached, only then can an applicant proceed to file an application for adjudication. And that's the third step. It's a more formal process where an adjudicator makes a decision after considering the application and written submissions from all persons affected by the dispute. It's important for an applicant to include all relevant details, information, evidence, and documents by way of attachments to the adjudication application, and include any previous Commissioner decisions you might wish to rely on, as you won't generally get a chance to do so later. You can amend things later, but it's best to do this all in the beginning. Once an adjudication application has been received and accepted by the Commissioner's office, they'll ask the respondent to the application and all those affected by the dispute to make a written submission about it. The applicant can ask for a copy of all the written submissions received and can have a right to reply to them. The Commissioner will then refer the application to an adjudicator for determination, which is the most likely next step, and they'll consider all of the material and submissions filed, and they'll make an order, usually without any oral hearing, determining the dispute. An adjudicator's orders must be complied with, and if they don't, then a party commits an offence. A possible fourth step from an adjudicator's order is potentially an appeal of that order to the Queensland Civil and Administrative Tribunal. But such appeals can only be made on questions of law, if there's some error of law made in terms of the interpretation of the Act or the exercise of powers in that respect. And the appeal must be filed within 6 weeks of the decision. So we hope that that's given you a good overview as to the manner in which these disputes can be navigated and the relevant issues, but we're happy to answer any questions that you have.
Thanks so much, Anthony and Hayley. After our somewhat glitchy start, which our apologies for that, we do have we've ended up with a fantastic presentation. Thank you so much. And I found every time I had a question, and as it went on, it got answered. So it was really comprehensive and interesting. Thank you so much. So we have had a couple of questions come through, and it may be the case that you've already covered these as you've gone through, but it's probably helpful just to sort of go over the ground again. So this first question comes in from Kate. She said, if this is actually kind of picking up on something that you really specifically referenced in the presentation. If damage has been caused to carpet, normally excluded because Body Corporate has not found the leak for 5 years, is the Body Corporate responsible? And particularly if the interior of the unit has been damaged because of ingress due to fault in common property, is the Body Corporate or the lot owner responsible?
I can answer that one. And I do think maybe we have answered this throughout. If the cause comes from the Body Corporate so the common property or property for which the body corporate is responsible, then the body corporate will be responsible for consequential damage. But in saying that, as I noted earlier, you'll need to prove it. So that might involve getting an expert out, and whether or not that's the body corporate's responsibility or the lot owners. If the body corporate's saying they don't think it's their responsibility, the lot owner might go out, obtain their own expert evidence, and commence proceedings against them to illustrate that the body corporate's responsible for the damage.
Thanks, Hayley. Kate's added an extra. I think this is connected to the same thing. She said steps taken to mitigate loss, such as professional building inspector, to find the source of the leak. Would that be reimbursable by the body corporate, presuming they were found to be responsible for it?
Generally not. Through the Commissioner's Office, as Anthony pointed out, there's the whole process that you have to go through. Generally, the lot owner would be responsible for obtaining their own expert evidence of it. If, for example, that's something which assists in rectifying the damage, then perhaps it's something they could claim, but generally that would be the lot owner's cost.
Right. Okay, great. I think that's really helpful clarification on that one. Thank you. So the next question comes from Stephanie. She says, following the recent floods, there seem to be a number of disputes with insurers about whether the damage was caused by flood, for example, overflow from the Brisbane or the Bremer rivers, or rainwater, for example, overflow from drains, which could not cope with the rain bomb weather event. Presumably, the insurance coverage varies depending on which it is. What can a body corporate be advised or required to do when dealing with insurers about this?
Sorry, what can the body corporate do?
Yeah, when they're dealing with insurers on that issue, I guess when the insurer is going to be saying, "Oh no, look, this is about overflow from drains," but actually it's because the drains couldn't cope, as opposed to flooding from the river, which is a very common.
I think that's really more of an insurance question. I think the body corporate, all they can do is, as with any other insurance policy holder, is to contact the insurer and inform them of the information they have available. I assume that they could potentially get a report or something which could prove their position, but like I said, that would be more of an insurance question than a body corporate question. There's nothing more that they can do than any other insured party.
Right. Okay.
It might be something the broker could assist with if there's a broker involved, someone that's knowledgeable of what's going on in that flood area. And yeah, as Hayley said, like at the ultimate, you could go and get a hydrologist or some sort of flood expert to give an opinion, but I assume there'll be other people around that particular scheme that might be in the same boat. So there could be common issues with neighbouring properties, and it won't be just the scheme perhaps, and it could be something you could collaborate with others to try and find out that answer. And people will have different insurers and different experiences, and that might all help in trying to resolve that problem.
Okay, terrific. Thank you. I think that's really helpful and good guidance there for Stephanie. This is a question that I've got, which is really about my own curiosity, I guess. If you're in a situation where damage is caused, it's not something that the body corporate's been insured for, and a particular lot owner has suffered damage that they're also not insured for, and they end up not being able to repair, so their lot ends up in significant disrepair, which would have a potential knock-on for other owners. Is there a role for the body corporate, I guess, to work through that sort of issue?
The body corporate can. There are some options and opportunities for the body corporate to enter a lot and to undertake repair works if they're necessary for them maintaining a scheme, and they can recover the costs of that from the lot owner,
right,
as I understand.
Yep.
A lot owner is responsible for their own lot, and they can be required to undertake those works themselves, but if they fail to do so, the body corporate can potentially step in,
yes,
undertake the work and recover the costs of doing so as a debt.
Great. All right. We've got a few more questions coming in. So I'm mindful of the time. It's 2:05, but we did have a slightly delayed start because of our technical problems. So if people are happy to stay on and you guys can continue on, we might work our way through a few more questions if that's okay.
Yep,
No problem.
So another question from Kate. Are legal fees of lot owners, internal dispute resolution step, I suppose, be reimbursed if fault from common property that caused the damage to the unit?
No, generally not.
Okay.
It depends. If you go through the Commissioner's office or, sometimes in QCAT there might be circumstances in which they might get their costs, but through the Commissioner's office, generally speaking, it's a no-cost jurisdiction.
Okay. All right, great. There's a question here from Fiona, which I think my question probably anticipated a bit, which was pointers on anticipating damage because the lot owner hasn't cleaned and repaired the lot post-damage, for example, mould that goes up to the other lot. So I think you've already answered that in terms of the body corporate potentially being able to enter that unit or that lot to repair. So let me just, hold on, I'm just working my way through this very tiny text here. What happens with full replacement value if the planning scheme changes and no longer allows the units to be redeveloped? That's a question from Jenny. What happens with full replacement value if the planning scheme changes and no longer allows the units to be redeveloped?
I guess that would be more of a planning question, but my understanding would be that if there's a unit block already built there, that they would have that zoning.
Yeah.
I don't know that I know the answer to that one.
Okay.
More of a planning or insurance particular question.
Yeah. Okay, no worries, completely understand that. Well, that brings us to the end of the questions that we have, although we do have one comment here from Steph, which is worth reading out to say, excellent presentation, and I appreciate the answer to my question. So thanks very much, guys.
Thank you.
All right, well, I think that brings us to the end. So thank you both so much for your time and your expertise and the thoroughness of that presentation, which was just excellent. Thank you to everybody listening and for your patience at the start. Great questions that came through in your engagement. Just a quick reminder, please complete the feedback survey that will pop up once you leave the webinar. That's really helpful to us to pass on to Hayley and Anthony and also for our own programming in the future. So we hope to see you again at the next CLCQ webinar. And also don't forget the CLCQ conference is on next week on the 11th and 12th of May here in Brisbane. It's not too late to get your tickets. If you're interested in coming along, we'd love to see you. All right, well, that's it from us today. Thank you so much, everyone, for your participation. We look forward to seeing you again soon.